Good morning. There is a strong political and legal storm around immigration in the United States, and the current climate is defined by tougher enforcement, expanded travel and visa restrictions, and growing uncertainty for people who depend on immigration processes to live, work, or reunite with family in the country. Communities, lawyers, and advocacy groups are reacting to these moves with a mix of fear, urgency, and determined organizing, as the rules on paper quickly turn into real consequences at airports, at borders, and inside neighborhoods where immigrants have lived for years. Federal authorities are stepping up enforcement operations inside the country, not just at the border. Thousands of immigration agents are being directed to focus on specific regions that the government describes as priority areas, officially emphasizing those with serious criminal records, but in practice, casting a much wider net that affects families, workers, and longtime residents who may have only minor or old immigration violations. One example drawing national attention is the deployment of a large federal presence to Minnesota, especially in communities with many Somali immigrants, where residents report an atmosphere of fear, increased stops, and concerns that even those with legal status might be swept up in broader operations. Local leaders, religious organizations, and advocates are warning that this level of enforcement risks eroding trust in law enforcement. As people become more afraid to report crimes or cooperate with authorities if they worry that immigration agents may be close behind. These internal enforcement surges are part of a broader national strategy that aims to increase arrest and deportation numbers in 2026. Analysts following immigration trends note that, after several years in which public debate focused heavily on the southern border, the emphasis is now shifting to interior enforcement, meaning that workplaces, homes, and routine interactions with police can all become potential points of contact with immigration authorities. This shift raises questions about due process, racial profiling, and the capacity of immigration courts, which already struggle with enormous backlogs and limited resources to adjudicate cases quickly and fairly. At the same time, the federal government is pursuing a more restrictive approach at the level of entry and visas, using the legal authority of the president to bar certain foreign nationals from coming to the United States at all. A new proclamation expands earlier travel bans and is justified on national security grounds, referencing legal provisions that allow the president to suspend entry of non-citizens deemed detrimental to U.S. interests. The latest version adds more countries to the list, many of them already facing instability or conflict, and blocks entry not only for tourists, but in some cases for students, workers, or even close family members who might otherwise have qualified for visas. For people in these countries, the ban closes off routes that they may have been planning and preparing for over many years, often at great personal and financial cost. To implement these restrictions, the State Department has aligned visa policies with the entry bans, suspending visa issuance for nationals of affected countries at U.S. embassies and consulates abroad. That means many applicants are not simply delayed. They are told that their cases cannot move forward at all while the policy is in effect, leaving thousands of families and employers in limbo. Lawyers report a wave of lawsuits on behalf of immigrants caught in this situation, arguing that the government is unlawfully pausing or refusing to process applications that should at least be considered on their merits, especially when the applicants have already passed multiple layers of security screening. These legal challenges may take months or years to resolve, but in the meantime, people's lives remain on hold, with no clear sense of when or whether the door will reopen. The Department of Homeland Security has also instituted broad pauses on immigration benefit processing for nationals of additional countries, significantly expanding earlier holds. This type of pause can affect a wide spectrum of applications, including green cards, work permits, naturalization requests, and changes or extensions of status. For someone who has built a life in the United States, a paused application can mean that they cannot legally work, cannot travel abroad to visit family, or cannot finalize the citizenship they have been working toward for years. Advocacy organizations describe people checking case status portals every day, only to see no progress, while employers stress over employees whose ability to remain on the job depends entirely on documents that the government is not currently issuing. Asylum procedures are undergoing major shifts as well, reshaping what protection looks like for those fleeing danger. Authorities are moving toward a model that combines faster decision timelines with stricter standards, which on paper sounds efficient, but in practice can make it much harder for people to assemble the evidence and legal support they need to prove their claims. A significant development is the decision to halt final determinations on pending asylum applications, even while new applications and interviews continue to be accepted. This effectively creates a two-track system in which older cases remain stuck in uncertainty, while newer cases may be pushed through under rules and interpretations that are still evolving. For asylum seekers, a pause on decisions means living in prolonged uncertainty about whether they will eventually be allowed to stay or be ordered removed. Many of them cannot safely return to their home countries, but without final status, they may struggle to access stable housing, long-term work, or mental health care, as their entire future feels conditional and fragile. Legal service providers have to juggle shifting priorities, deciding whether to invest resources in preparing older cases that may not move soon, or to focus on new arrivals who face tight deadlines and complex screening interviews at the border. The list of countries facing new or intensified entry bans also includes places experiencing war, coups, or internal conflict, such as Burkina Faso, Mali, Niger, Palestine, Sierra Leone, South Sudan, Syria, and Laos. For citizens of these nations, travel to the United States for protection or opportunity was already difficult. With additional restrictions in place, regular migration pathways grow even narrower. As a result, some desperate people may feel pushed toward irregular routes and smugglers, which are far more dangerous and exploitative, simply because the legal paths that once existed are being sealed off. Refugee resettlement is also affected by these policies. New rules and funding decisions are reshaping how many refugees can be admitted and from where, sometimes privileging certain geopolitical priorities over humanitarian need. When entry is suspended or delayed for people already approved for resettlement, they may remain in precarious conditions in third countries, stuck in camps or temporary housing without a clear timeline for movement. Faith-based and non-profit agencies that partner with the government to welcome refugees must continually adjust their plans, staffing, and local community support as the numbers and timelines fluctuate. Behind the scenes, immigration policy is increasingly tied to technology and data collection. There is a growing reliance on extensive vetting that may include social media screening, biometric checks, and automated tools designed to flag perceived risks. Supporters argue that this enhances security and allows for more targeted screening, but critics warn about privacy concerns, potential algorithmic bias, and the lack of transparency around how these systems operate and how decisions can be challenged. People applying for visas or immigration benefits are sometimes asked to provide decades of online history, which can feel invasive and may be difficult to document accurately, especially for those who have lived through conflict or displacement. At the border, the enforcement environment is more complex than simple slogans about tightening or loosening control. Some border sectors are reporting lower crossing numbers compared with previous peaks, which officials present as evidence that new deterrence and enforcement measures are working. At the same time, humanitarian organizations point out that when one route becomes harder, migration often shifts elsewhere, sometimes to more remote and dangerous areas where people are at greater risk of dehydration, violence, or exploitation. Border communities which live daily with the reality of migration must navigate the balance between security, economic ties, and basic human compassion for those who arrive seeking safety. Nonprofit organizations, attorneys, and mutual aid groups are responding to the current wave of policies with increased outreach, community education, and legal action. Know Your Rights workshops teach people what to do if immigration agents appear at their door, how to prepare emergency plans for children, and how to gather documents that may be crucial if they ever need to present their case before an immigration judge. Legal clinics and hotlines are seeing high demand as people call to ask whether the new bans or pauses apply to them, whether they can still travel, and how to respond to notice letters and check-ins. For many families, these community networks become lifelines that help them navigate a system that feels increasingly complex and unforgiving. The political debate around these changes is intense and often polarized. Supporters of the stricter measures argue that the United States must prioritize national security, control who enters the country, and reduce what they see as abuse of asylum and other protections. They contend that tougher rules and more robust enforcement will deter unauthorized crossings and ensure that the immigration system serves the interests of citizens first. Opponents counter that the policies are overly broad, discriminatory, and out of step with international human rights obligations, punishing entire populations for the actions of a few and closing doors on people facing real danger. Economic and demographic realities also shape this conversation. Many sectors of the U.S. economy, including agriculture, caregiving, technology, and healthcare, rely heavily on immigrant workers, some of whom have temporary or precarious status. Employers worry that stricter rules and long processing delays will make it harder to recruit and retain the workers they need, particularly in rural or specialized industries where there are already shortages. At the same time, debates over wages, training, and worker protections complicate the narrative as unions and labor advocates call for fair conditions for both immigrant and U.S.-born workers. For individuals and families navigating this shifting landscape, the emotional toll can be profound. Parents wonder whether it is safe to send their children to school, not because of the school itself, but because they fear what might happen on the way, or whether they will be there to pick their children up in the afternoon. College students on visas worry that a change in rules or a new pause could disrupt their studies overnight, ending dreams they have built over many years. Mixed-status families, where some members are citizens and others are not, live with the constant tension that a traffic stop or a paperwork delay might split them apart. Yet amid this uncertainty, there is also resilience and a determination to keep pushing for a more humane and workable system. Community groups organize rallies, lobby visits, and campaigns that seek to highlight individual stories behind abstract policy debates, putting names and faces to the numbers that often dominate headlines. Lawyers craft novel legal arguments to challenge the scope of presidential power over entry and to defend the rights of those already in the country to have their cases heard fairly. Faith communities open their doors to provide shelter, food, and spiritual support to people who feel targeted and afraid, reinforcing the idea that solidarity can exist even when laws feel harsh. Looking ahead, conflicts over immigration are likely to remain central to national politics for the foreseeable future. Courts will continue to play a critical role, either upholding or blocking parts of the new measures, and each ruling will shape how far the executive branch can go in limiting entry, pausing processing, or ramping up enforcement. Congress still has the authority to rewrite immigration laws in a more comprehensive way, but deep partisan divides have made major legislative reform difficult, leaving presidents to rely heavily on executive actions that can be reversed or altered by future administrations. For people whose lives are directly affected, each new announcement or lawsuit is not just a political story, but a personal turning point that may determine where they live, whether they can work, and whether their families can stay together. If you found this video helpful, please consider subscribing to H-1B Immigration News for more clear, accurate, and timely immigration news. Share this video with someone who needs to know. Goodbye.